are charged with coercive control could have been charged under a number of statute that was already available to the prosecutors in those jurisdictions. And that's the same case, I think, here in Canada. If you think about what is coercive and controlling behavior, criminal harassment, assault, sexual assault, forcible confinement, human trafficking, uttering threats, fraud, and stalking are all criminalized behaviors. So my challenge remains that while we have so many tools in the box, why do we want to add this one more thing, which is a contextual nature of the crime? And instead of giving proper education to our police officers and our prosecutors and our judges in understanding that context, adding this one more thing would unfortunately, in my opinion, add another layer of barriers and access to justice to the survivors, because now they have one more thing. And it might also give them this false notion that this is, coercive control is not criminalized. But in reality, the beyond reasonable doubt test would still remain the same. And they would still have to prove all of those actions or those situations that I just listed and more. So I really definitely find it really challenging to think about that, how it will resolve a problem which lies in lack of understanding of the context by the frontline responders and prosecutors and decision makers. So I do not believe that it will actually break the cycle of violence as suggested by you, Honorable Member. And in fact, that's also the evidence coming out of the countries and the jurisdictions where it has been criminalized.
If I could just respond to that, I take some of your points. I mean, for me personally, and again, this is just my anecdotal experience, coercive control takes the form of manipulation, and it is manipulation that is meant to control that isn't criminal harassment, whether it be repetitive, unwanted behavior, because the person might not even realize that they're under the thumb of their abuser. And often, in my experience, it takes the form of things that aren't illegal. Having a bank account, controlling all of the finances, isolation of a person that is so coordinated as to leave the victim vulnerable. That isn't covered under human trafficking. It's not covered under assault or criminal harassment. But the end goal is to ultimately leave the person more vulnerable. And I take your point about the nuances in the law and the difficulty of proof, and maybe that's incumbent on us to change some of the enumerated ways of identifying it. But in 20 seconds, what do you say to that?
I think I can agree with you on the point that none of the provisions that I listed have the repeated nature of the abusive acts as you are referring to. But again, my point is that it is the context of the violence that is not understood by the existing system. And unless and until we fix the existing system, we are actually putting the cart before the horse.
Thank you very much for that. I will move to Mr. Mendicino for 6 minutes.
Thank you, Madam Chair. Thank you to both of our witnesses for the very thoughtful interventions. And I'd like to start with a question to Ms. Parsa, if I might. And I take from your preliminary remarks that there are some underlying structural and systemic issues with the criminal justice system that need to be addressed before we consider adding yet another provision, which would be under the criminal code, to deal with coercive control. And to my recollection, you referred to looking at ways to devise alternative dispute resolution or alternative judicial resolution measures. Could you elaborate a little bit on what that looks like in your view?
Sure. So that's a big question, but that's something that LEAF has been engaged in a lot of research in this past year. What we're talking about is restorative justice and transformative justice models, and these can take a variety of different shapes, and they can exist within the legal system or outside the legal system. And so many of these take place in the community, and they involve a survivor who has access to the resources, but has been able to seek out a resource in which they feel safe and able to have some sort of resolution with their in their situation of violence. I think, to be honest, this is perhaps difficult to imagine in a situation where there is imminent harm, and it is. But I think this is the kind of resolution we are hoping to move towards for survivors who are seeking validation and recognition. Based on a lot of research that we've done, experiences of going through a restorative justice process, which can often mean it can mean something as simple as writing letters to the person who is the accused and sharing kind of thoughts through that. There can be a facilitator. It can be a long process involving therapists. Oftentimes, you don't even have to see the other person. Like, you don't have to come face to face. But these experiences often have been shown to provide survivors the validation that they don't get in the legal system. So they feel much more like their perspectives and their experiences have been recognized, and they have been, person who harmed them has become accountable for their actions. And there's a sense that they feel healed in a way that the justice system often does not provide. And so that's kind of what I'm speaking about. We've actually released a very lengthy report this past year, if you're interested, about specifically alternative and restorative justice models for sexual violence in particular.
I am interested, and if you'd be willing to provide it to the clerk, I think all members of this committee, and in fact all parliamentarians, would benefit from Leaf's study of restorative justice models like the one that you've just described. And I agree that in some cases that restorative justice is a more appropriate, more validating model than going the full conventional criminal law route. And so I did want to validate that point of view. There may be cases, however, where restorative justice is not available. Would you agree with that?
Of course. I think our main point when speaking about restorative justice is really that we want the options. We think that survivors should have the options to pursue whatever form of justice they want, and that the criminal legal system shouldn't be kind of the only route forward.
And is it true that in a case where the victim or the survivor, and indeed all of the participants, do not voluntarily agree to participate in restorative justice, that may not be the most appropriate option?
Of course, there has to be consent on both sides to take part in these processes.
And so, I gather, turning back to this private members bill, which has been advanced by my colleague, Mr. Garrison, that's really the scenario in which the bill should be contemplated, perhaps where other alternative models may not be available for one reason or another. It may be because parties don't consent. It may be that there are some cases that are egregious, where serious violence has been involved. And as a result, we may have no other choice but to resort to the criminal law, despite the systemic challenges, which I think you've appropriately identified. In that scenario, what do you say? Is it that the existing laws that are on the books are sufficient or adequate to deal with coercive control, or do you acknowledge that perhaps by adding some additional language that defines coercive control, and I think Mr. Caputo provided some good examples for the committee and for you to contemplate, that it may make sense to look at adding additional provisions to deal with this type of harm towards disproportionately towards women?
I think I certainly understand that this desire to respond, especially when there's imminent harm or a situation of urgency, and survivors feel like they need help quickly. But I just go back to what my colleague, Ms. Mathieu, was saying, where I think the problem isn't that there aren't laws or there aren't these tools. The problem is that they're not used properly. And the existing laws that they are not being adequately used in these situations.
Thank you.
And
thank you very much for that response. Monsieur Fortin, alors, c'est à vous maintenant.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you, Ms. Batu. Ms. Parson is with us today. The issue of coercive and violent controlling behaviors is a part of our responsibility to ensure that people are safe and not be victims of violence in whatever form. And in that sense, Bill C-332 seems to me to be useful. There already have been criminal code just provisions for threats, rape, sexual assault. Many of these issues are covered in the criminal code. And so we could delimit this kind of violence. But when we talk about controlling or coercive conduct, or we talk about the control exerted by one person over another, often a spouse with their partner, there are no specific provisions in the criminal code. And I understand the position that you're both defending, and correct me if I'm mistaken, but I think you advocate for training for all of the players in the justice system. But is that not maybe too little? Should we not be more proactive and say, yes, training, but also ensure that the message that we're sending to society is clear? If you act in such a way with your spouse or your partners, and know that it's not training that you're going to get, it's a trial with a sentence in the end. Is it not necessary in the current situation to have such provisions, even though I recognize that 332 needs to be modified a little bit? Do we not have to have clear offenses in that respect? So, Madame Metu first, and then Ms. Parsa, could you please answer? Thank you.
Appreciating the thought process, and I think I already said that in my opening statement, that I commend the intent behind it. I think the challenge is that the threshold for a coercive control behavior without satisfying the individual incidents of abuse, which are already as part of the toolbox for the police officers as well as the prosecutors, and those behaviors are already criminalized. So what I am challenged with, and what I am presenting to all of you to think about, is that what this will do is it will create another form of abuse, and then it bears noting for all of us to understand that then this needs to actually be added to as a notion of compounding abuse, right? So the abuse is already happening, and these are the individual incidents, and now we will, on top of it, add the layer of a compounding abuse. So all of those incidents need to be proved. So my question to you is, well, how many incidents are we talking about? How many incidents will make coercive control? What will a survivor will be required to prove? Are we asking survivor to prove that she felt controlled and then that she didn't have a recourse? How will the intent of harm be proved? So I think my challenge is the practical implications. And I feel like as much as it will look really brilliant on the books to have this, it will be really difficult to be utilized in the courts. And we have many other such provisions on our books which were made. Those changes were made for survivors. So criminalizing of the forced marriages, criminalizing of the FGM. There are many other such changes that have been brought forward to protect survivors, but those are never used because they're so difficult for the police officers to understand and for prosecutors to bring forward. And they always go back to the already existing tools and charges that they can already lay. I hope that helps in contextualizing what I'm trying to say. Thank you.
Merci. Madame Parsa, vous avez...
Thank you. Ms. Parsa, do you have anything to add?
Yeah, so I agree with everything that Ms. Mathieu just said. And I just want to point to even the conviction rates that come out of these cases are very low. There was a study that showed in England and Wales, of the 7,000 arrests that were occurring within the time span of the study, only 3% had a conviction rate that was successful. And so even for survivors who are seeking this avenue, the reality is it is not going to